Okay, the little legend having come up that the recording has started. I hope that this is recording, and I hope that you are well, whoever you may be. This is kind of a new one on me, having presented at a number of conferences over the past year remotely, doing it via recording, pre-recording, and not knowing who's going to be there or who introduced me or how they introduced me. Allow me to introduce myself. My name is Rob Slade. I started in research into security and researching malware. So you can take a picture of the QR code there and get some information on me in the full confidence that it's absolutely safe, bearing in mind that I know every possible way to get people to install malware on their machines. I have taught at a number of conferences, presented at a number of conferences, and taught. I'm going to be teaching next week. During the pandemic here, I primarily consider myself a teacher. I've taught on 5 continents. In terms of legal stuff and presenting in court, I did write the book Software Forensics, and a bunch of other things, including most recently cybersecurity lessons from COVID-19. But I should probably get started on presenting technical evidence in court, because that's what you're here for. At least I assume so, unless you stumbled into this room by mistake. As blind random chance would have it, I'm doing some security lectures here in Vancouver, and next week a longer version of this same presentation is going to be given, and there's the URL that gets you to join, and the URL that gives you some information on what the series is all about, and the URL that gets you into my YouTube channel so that you can see previous ones if you are interested in any of that. And if you're not, we'll just go on with this. Right. Okay, CSI Yaletown is not going to help is the subtitle here, because well, we'll talk a little bit about CSI and the CSI effect a little bit later here, but the way you present technical evidence in court is not the same way that it gets presented in all the cop shows and lawyer shows on television. I have in teaching, well, much of the stuff that I've been teaching is the CSI, sorry, not CSI, CISSP courses, review seminars around the world, and which means that, interestingly, as a Canadian, I have been teaching American law to Americans very much of the time. But anyway, I have had to present, I have had to deal recently with consulting with an awful lot of lawyers on patent troll cases, and it's just different than they show it on the TV, and so I want to point out a few of those things. And because we are dealing with legal issues and all kinds of legalities here, it's probably important that I tell you that I am very definitely not a lawyer. I am a techie, I'm a geek, just like all of you guys. And that becomes important because lawyers don't just work in a different industry than we do, don't just have a different trade than we have. Lawyers are a different species. When we attack a problem either there's going to be an answer or there isn't. And if there is an answer, there's about 16 different answers, and you pick the one that you prefer best. But the solution is the solution, and there is a solution. That's not the case with lawyers. With lawyers, basically you ask a lawyer anything. It doesn't matter what the question is. The answer is always going to be, it depends. And so, the way that they think and the way that we think is not the same. And in the same way that it's important that we as security professionals learn business, and so that we know that we are supporting the business that we are supporting and working for. When we are helping with a legal case, we are helping the lawyers, and we have to understand their mindset and consider what they will consider important, not just what we consider interesting. Anyways, we will get through to this. And I'm sorry that this is not going to be a cut and paste. Here is how you present. Here is what you need to do. Here is a process to follow. Because of course every case is going to be different. So we'll look a little bit at some of the principles here in the law. I seem to have jumped ahead of myself, so we'll just go back here. First of all, most of the stuff that you see on TV, because it's shot in the United States, is going to be roughly under a common law legal system. And actually, unfortunately, common law is not that common. There's only 42 countries in the world that have common law legal systems, and even in the United States, for example, which federally is under common law legal system, and most of the states are under common law legal systems. They have two states, Louisiana and California, where their legal systems at the state level are based on the civil or code law legal system. And this, in fact, is the most common one. This is where, the state writes the laws. Well, that's fairly obvious. But the common law legal system is going to be based on some kind of a charter document. They've got the Magna Carta in the UK, which is where the whole thing started. In the United States, they've got the Constitution. Here in Canada, we've got the Bill of Rights. Civil or code law legal systems, you have to have a specific law or something isn't legal. For example, if a particular country in their civil law legal system had not specified that murder was illegal, then murder would not be illegal. Under the common law legal system, there are certain principles, and the fact that killing somebody is a bad thing is basically one of those principles, and so you don't necessarily have to define murder in the law for it to be illegal. That has a lot of implications for those of us in the technical world, because of course technology and the technical world, the information society is changing and putting a lot of pressure, creating all kinds of new situations that civil law legal systems have not yet addressed. As one example, under the common law legal system, if somebody writes malware and releases malware, that can be considered mischief, it can be considered trespass, it can be considered a number of things under the principles of the common law legal system. But if you don't have a specific law in their civil or code law legal system that says that's the wrong thing to do, then it isn't wrong. And so when, in our interconnected environment these days, it's important because you may be dealing with other jurisdictions very easily. I mean, on the internet, everybody lives next door to everybody else. So there's that. Now, there are other legal systems, religious or traditional law legal systems. They can have factors bearing into this, but do remember that a lot of the things that we think are universal, such as the presumption of innocence, even jury trials, things like that, are all based on the principles of the common law legal system, and they may not hold in some of the jurisdictions that you have to deal with when you deal with a complex system. Now, there are different kinds of laws under all of those things. There is criminal law. That is, this is specifically criminal. And criminal law is something that you can put somebody in jail for, as a basic sort of division here. Civil or tort law has to do with lawsuits. And again, don't confuse the civil or code law legal systems with civil or tort law under various types of legal systems. The tort law, this has to do with lawsuits. The intellectual property is a big issue here, and I've had to deal with far too many intellectual property cases, and particularly patent trolls. You can get a decision that somebody owes you money because you have harmed them in some way, but you can't throw somebody in jail under a lawsuit, in regard to a lawsuit. Administrative or regulatory law, it's sometimes called, has to do with specific industries, enterprises, specific fields of work. Banking is subject to regulations. Healthcare is subject to specific regulations. There are specific administrative or regulatory laws that relate to those, and some of the laws that you may have to deal with are because of specific regulations for a specific industry. Now, I have mentioned jurisdiction. That is, where did the crime take place? Where then can it be prosecuted? And unfortunately, that particularly, as I say, in our interconnected world, can be an issue. I remember a case, casinos, are basically illegal in most places in the United States. You can't have a casino. Online gambling is therefore illegal, although apparently it's not illegal to run a casino. It's only illegal to have American customers. It's kind of bizarre. But of course, people have set up online casino systems. And I remember one case where an online gambling casino was set up, primarily American customers, of course. The company was headquartered in the Cayman Islands. The servers were sitting in the basement of a hotel a few miles away from me in Burnaby. So, where is the jurisdiction there? Whose laws are going to apply in that kind of a case? You run into that all kinds of times, as I say, on the internet. Where did something originate? Where did somebody get hurt? Where were things transferred? Jurisdictional issues can get extremely complex. I remember the DC snipers, the 5 separate jurisdictions, when they finally caught the people, wanted to try them, and there was this big wrangle about who was going to try them first. Anyway, now, as I mentioned, lawyers are different than us in technology. Code works or it doesn't, and the background and the documentation are irrelevant. An awful lot of people think that documentation itself is irrelevant. I happen to disagree there, but in the legal world, you immediately run into all kinds of complexities in the situation. And so your preparation is important. Your background is important. If you are a witness, I'll talk about expert witnesses in a bit. Documentation is often vitally important, and of course, the law itself. So, as I say, you're going to have to see this from the lawyer's perspective. They are in charge in this situation. Now, some additional concepts here. Liability. There doesn't have to be, in terms of civil or tort law and lawsuits, there doesn't have to be a specific crime, just a harm to somebody. And you don't have to specifically do something to somebody. If you do something and your action, even though it wasn't directed at someone, harms someone, as sort of collateral damage, if you will, then you are liable. If you should have done something, if a reasonable person should have done something to keep someone from harm, then you are liable. That, if you don't take the steps that you should take, that's negligence. So these are concepts that you are going to see in legal situations, and you are going to have to demonstrate, yes, this person was liable, or no, this person wasn't liable, because the steps that you were saying that could have been taken were irrelevant, were not steps that a reasonable person would have taken. And these issues can be pretty interesting. There's also the issue of due care and due diligence. Again, the steps that a reasonable person should take, that's due care. Looking at dictionaries of law, sometimes they will define due care and due diligence as the same thing. Sometimes you will get basically a definition that due care is what you should do. Due diligence is how you prove that you in fact did it. So interesting related concepts there. Now, the crypto wars are a sort of a recurrent legal battle. I can remember the crypto wars back in the 90s. You can tell I'm old. And we seem to be fighting this recently all over again. Law enforcement tends to say they need to have access to communications so that they are able to do wiretapping on the bad guys and all everything that goes along with that. This is an ongoing fight because, of course, anything you do to weaken encryption weakens security overall. For example, if we say that we can't have strong encryption, we can't have online commerce. How do we protect using credit cards online or anything like that? And of course, cryptocurrencies themselves rely on encryption. And so, all kinds of battles are going to be fought in this, and this is probably one that is going to be ongoing, or at least recurrent. It's going to keep coming back and back again, and it is not something that's going to be resolved at any time soon. So finally, down to presenting evidence in court. And there are different types of evidence. Now, the most regarded type of evidence is direct evidence. That is witness statements, which is kind of weird from our technical perspective, because research has definitely shown that witness statements are extremely unreliable. Everything in investigation, quite apart from the law, everything in investigation, managing of an investigation, is a there are all kinds of specialty fields in there, one of them being interviewing and interrogation, because you don't want to lead the witness, not only because that may, it's illegal, for one thing, and it may lead you astray, but because it's very easy to lead the witness without even intending to. When you hear something interesting from a witness and just, leaning forward and widening your eyes because you're interested in what they're saying, feeds back to them. We are very quick to pick on these things. And if they want to help you, they will start to create facts and extra supporting factors in their story. And certainly, it's very easy to show you set up a situation and have a little play going on, and then interview everybody who saw it and say, now, tell us what happened, and see the differences in the statements that people make. But it's very easy to get them to mess this up. And so you say, well, tell me about the guy in the green hat. And they say initially, well, I don't remember the guy. They go, oh, sure, he had that red vest on and blue tie, And pretty soon, because of course you are feeding information to them, they're picking it up, and they will remember the guy in the green hat and the red vest and the blue tie, when in fact there was no such person. So, but this is interesting. In traditionally, direct evidence has been the best type of evidence that people want. Now, real evidence, this is a tangible object, and we think in the technical world, yes, we're dealing with tangible objects. We're dealing with computers, but unfortunately, most often it is not the computer that is the important thing. It is, in fact, the information, and the information is not tangible. We aren't dealing with real objects. We are dealing with very small magnetic variations on a physical object. So, real is DNA, real is hair samples, real is mud spatter, blood spatter, things like that. That's real evidence. Real is a television with a serial number that was recorded as being shipped to this company, and now it's being found in this person's possession, and therefore they stole it. That's real evidence. But our evidence is most often documentary. And our, the information that we are extracting from a computer, that's documentary evidence. Not only is it documentary evidence, because of the nature and the fragility of digital evidence, it's even hearsay. And very often it is considered to be hearsay. Business records are not actually evidence of a transaction, they're evidence surrounding a transaction. And so most of our evidence is documentary. Most of it has to be supported, and it has to be interpreted. And this is where we get down to the last one, demonstrative. And this is where the CSI stuff comes in. And we have to build demonstrations of why our documentary evidence does in fact mean what we say it means. So those are the types of evidence, and of course the documentary evidence is the most important for us. Hearsay is when you say you heard somebody say something, and that's generally speaking not accepted in court except in exceptional circumstances, and we have to give reasons for why this hearsay is something that should be heard. There has to be backup testimony. How was the information created? How was it handled? How was it protected? Was there any deviation from the standard process, and why were any of those deviations made and should be accepted. All of this has to be backed up when you are dealing with documentary evidence. So that is going to be vitally important. Everything that you decide you need to present in court is going to have to be backed up in that way when it comes to computer information and computer evidence. There are rules for evidence when you are presenting in court if it's going to be acceptable. Now, you will find various lists of the rules, and there are different numbers of rules and that sort of thing. Basically, the principles here are what you will see. First of all, it's got to be relevant. And this is something of particular problem to us. We may find something that we find really interesting, but unless it's specifically relevant to the case, to proving that the person that we say did something, identifying them or indicating that this was the action that they took, it's got to be relevant to that. And if it's not specifically relevant, it's never going to see the light of day in court. And in fact, there are different types of evidence that may, from our perspective, be relevant, but because of that last rule, the best evidence, we may not be able to present certain things. We have to present the best evidence, the most relevant, the evidence that is really going to give the court the best picture of what happened. Admissibility is an interesting concept. First of all, there's the legality of it. Is this, well, and that's mentioned as well, was this evidence collected in a proper manner? Anything that deals with illegal search and seizure, and there are rules, what you cannot search, what you can't seize, that evidence then becomes tainted and can't be presented in court, or sometimes even if it's presented in court, cannot be used in the final decision. We've had a recent case here in Vancouver where someone actually killed someone, but because all of the evidence that was gathered relied on a specific piece of evidence that was kept illegally, then all of that had to be thrown out. And in fact, the court case, the fact that this person was guilty, had to be thrown out because of the tainting of that evidence. It should not have been admissible in the first place. And in regard to the admissibility here, again, the chain of evidence, the issue of the chain of evidence or chain of custody. Who collected this information? How did they safeguard it? Was it protected? Was it sufficiently protected? Did anyone have access to it between the time it was collected and the time it's presented in court? And for what purpose? So that becomes a very important issue. The chain of evidence, chain of custody is vitally important when we're dealing with this. Monitoring and surveillance, very interesting situation, particularly when we're dealing with privacy laws and even labor laws. If you have employee monitoring, if you have surveillance in your place of work, make sure that you keep it to a minimum so that you don't run afoul of privacy issues. Make sure that you have agreement or permission from your workers or even customers. And that becomes very interesting. There was a case in the United States where a police station was, of course, under video surveillance, and big signs about video surveillance was done, and someone was caught, and this evidence was taken into court. And in court, that party challenged because the recording that was being used was from a surveillance camera in a broom closet. And this lawyer said that nobody in their right mind would put a surveillance camera in a broom closet, and therefore his client had a reasonable expectation of privacy. I do not know how that case came out, but even the fact that the argument was made shows how interesting some of these cases may become. And again, privacy is now a specialty on its own. There are specialists in issues of privacy. We have to think about the privacy directives, GDPR being basically an extension of the privacy directives, has the basic principles there. Most countries around the world that have privacy laws have based their privacy laws on the privacy directives so that they can have equivalent protection, because one of the privacy directives said you can't transfer information to a jurisdiction without equivalent privacy protection. So this is everybody except the US, which basically does not have any privacy legislation at all, which is really interesting. There is an issue called discovery. This is an adversarial system. Again, that is a difference. We work in a collegial environment, even when we're dealing with intellectual property and patents and things like that. Basically we want to share information with our colleagues. We write papers, we do this. The law and particularly the courts are an adversarial system, and you've got two sides, and somebody is there in court not to prove you wrong. They are there just to make you look bad. That's all they have to do. I mean, as an example of this right now in the political realm, Justin Trudeau is not, doing great things. He's trying his best, maybe with a bunch of different situations. And Aaron the Tool is having a field day saying Trudeau is doing everything wrong. Now, he doesn't have to prove that he's got better ideas, which it doesn't sound like he does. He doesn't have to prove that something specific that Trudeau has done is wrong. All he has to do is make him look bad. And the same thing happens in court. And they get to see everything that you have done, everything you have discovered, everything that you are going to bring against them. So whereas previously in a lot of companies we're starting with information technology and our storage capacities going up, saying we're just going to keep everything. Now in more legal terms, companies are starting to think, maybe we should keep what we keep to a minimum, because if you face a court case, it can be very expensive to provide the opponents with everything that they want to see. So bear that in mind. So digital evidence is fragile. It is extremely fragile. There is, if there was any change, there is no way to say what the change was, who it was changed by, when it was changed, what the original data was, and whether it was of any significance. So if anything is changed, very often your evidence is worthless, and that's where this chain of custody issue comes in. It is very important to protect digital evidence. When you make a copy of a hard disk, for example, you don't make a backup, because most backups set the archive bit on every file that they back up. And so they are changing information on the hard drive. And as soon as you say that, you, for one thing, you lose a lot of evidence about, what files people may have looked at. But the fact that you change it means that, now you've already got modified data. And that can be challenged in court. And again, somebody doesn't have to prove that what was changed was what's important to the situation. All they have to prove was that you allowed a change, and therefore the evidence is unreliable. So you, when you have a hard drive, you make a bit image copy. You make a bit image copy with usually specialized hardware that is not going to write anything to the hard drive that it's reading. You are going to collect everything with the logical space and the slack space. You are going to collect the files. You are going to collect the blank space after the files, the bits in between the files. You're just going to collect absolutely everything. And that is going to be your bit image copy. And then you make a copy of that bit image copy, and that's your working copy. So that if anything goes wrong with that, you can go back to the copy rather than going to go back to the original hard drive, because of course the chain of custody is going to be interfered with if you have to go back to the original hard drive. Anyways, that is an issue that you have to deal with. Now, when you are presenting in court as a witness, you can be a witness of fact, which means you just get to say, just the facts, ma'am, as the phrase has it. Or you can be an expert witness. But the court gets to decide whether you are an expert witness. An expert witness may provide an opinion, and that's, very often, that is what you need if you are going to do any interpretation of saying, well, what this means was, as soon as you say that, that's an opinion. And you have to be an expert to be able to do that. In the United States, there's a decision called the Daubert decision. The judge, individual judge in the case, gets to decide whether you have the skill, training, and experience to be an expert witness. Interestingly, in the US, under that decision, the bias is unimportant. You can be a very biased person. You can work for one side or the other. That's not important if as long as you have the skill, the training, and the experience that is necessary. In the UK, you cannot be an expert witness if you have a possible bias. And so a friend of mine who worked for the high-tech crimes unit over there, he was never able to present as an expert witness in court because the fact that he worked for the police meant that it was automatically assumed that he would be biased, and therefore he was not allowed to be an expert witness, even though he was a very expert individual. So the presentation, and this again, you remember back to our list, this is the demonstrative type of evidence. There is going to have to be a lot of preparation. You're going to have to think of who your audience is. And this becomes very important. Your audience, you will remember here, and this is particularly when we deal with fairly complicated technical issues. Your audience is, two lawyers who, may be very smart people. They got through law school, but they may not know anything about technology. And a judge who is, you will remember, by definition, an old lawyer, and 12 people who were too stupid to get out of jury duty. And so you have to present, you have to prepare your presentation remembering that audience, remembering how you are going to lay out for this audience what these complicated issues mean, and why that supports your contention that, you know, what you say happened. Of course, it has to be relevant. The preparation can really take a lot of time. I can remember one particular case, and I was days and days with multiple different lawyers being questioned as to what I was going to say in court. And because the lawyers did not understand the minutiae of the technical stuff that they were dealing with, the court case was dealing with. I can remember one session, well, many of the sessions were frustrating, but one in particular was extremely frustrating. And I finally asked the guy, you know, what is it that you want me to say? And he said, I can't tell you, because telling you would be coaching the witness, and that's illegal. But they do, you know, take you through hours and hours of preparation, asking you the questions, seeing what your answers are going to be, what kind of follow-ups they may need to do. It takes an awful lot of time and preparation, you know, for what may be, you know, 5 or 15 minutes on the stand in court. Hours and hours and hours of preparation, and that's quite apart from putting together any kind of presentation to demonstrate the technology. And here's where CSI comes in, because CSI has a lot to answer for. The TV show, the various TV shows, the whole franchise, and many other television shows, and the presentations that they do, but particularly CSI. CSI gave a lot of people the impression that any technical issue could be covered in court with this, you know, colorful, animated computer graphic that just makes it absolutely clear that what they say actually happened. And that's all done within, you know, 45 minutes, excluding commercial breaks, and then we can all go home for dinner. And so the you know, court cases have increasingly run into this, that this is what the jury expects these days, and unfortunately that is just not reality. And you have to, and the lawyers you're working with are going to have to address that issue carefully as to what the expectations are going to be for the audience, and are you going to be able to, if not exactly meet them, at least deal with the expectations that people have for these kinds of presentations. And that is why CSI Yaletown is not going to help. I hope that this has helped. I hope that you are enjoying BSides Vancouver this year in a very strange situation. I hope you are all being kind to each other, being calm in all the weird situations that we find ourselves, and being safe. I hope that you have all registered for your vaccine. And now I suppose I turn this off, and somebody opens up the floor for questions or discussions or something like that.